That's different. Yes. What did the judge say? I thought it had.
Maybe one already has it.
He may, and that's kind of.
Some more in addition to the two.
Just one full long.
Well, I feel like, if it was the other person,
Put it on the radar.
well, put it on the radar, and since they do not post it, we address and making sure that it goes through.
He's got a little.
I know, he did, I'm getting the original bill passed, cause it won't be which doesn't happen often, so.
Yeah, we got Ross and
Yeah, and when the foundation is
That's their lawyer?
So,
I'll be there.
Kim's aware.
Yes.
Good, we'll be there.
Yeah, well,
Commissioner's gonna be there.
Chose not to.
So I invited you then.
We've gotten strict approval from there, from the right people.
And my girlfriend is a flower.
Oh, do you?
That's mainly.
That was part of a volunteer role for y'all, or for them.
That's right, that's right.
Well, I know Kim said if we need to check the budget.
I can print another one if
I
someone
know
comes.
where you are, I can come get it afterwards.
Okay, yeah, absolutely.
Let's do that, let's hold on to what you got, in case somebody else shows up.
I think we'll go ahead and get started. We don't have a quorum, but,
We don't need one.
I'm gonna let, there's a draft of an amendment that was just given to me that I have not seen, and you just provided that. I'm gonna let you explain what that is.
Right, okay. Okay, all right, members, first of all, thank y'all for being part of this subgroup. I think it's very important that we continue the dialogue, and based on the last two committee meetings over the weekend, spent time reaching out to multiple stakeholders out there. And what you have in front of you is, what Adam just gave you is a comprehensive proposed amendments. What I like to do is go over each one and kind of get your feedback, issue concern, but this address issues that committee members had last meeting, and also some of our stakeholders. So if you look at—
Let me ask this, does this, what we were provided today, encompass the amendments that were done previously?
yes, it do. Yes.
Okay.
Yes. And so with that, if you look at with the amendment there, it starts on line 5, say replace line 69 on page 3. So we look at the bill that was introduced, look at line 69. And since we're making a reference later on in the bill about law enforcement, we just put this in the heading of the bill. That's all. Then later on in the bill, it will elaborate. And what that is, once again, this was in the previous amendment that we discussed, to require the department to promptly report certain allegations to law enforcement. And then also the bill later on is going to talk about to distinguish between criminal investigations and child welfare investigations, and to require the department to prepare this continuum. And distinction between criminal investigation and child welfare, that came from a discussion in our last meeting. Several members had questions about that. So the amendment is going to define those definitions that already exist in code.
This doesn't change any current policy.
That's correct. That's correct. Then the next, on line 12 there, the Fourth Amendment, it states, replace line 77 on page 3. So let's go to line 77. As mentioned, if you look at the amendment, it defines child welfare investigations, and several committee members was asking what that entails. It's already existing code, so we should take existing code, the definition of child welfare investigation, and plug it into the bill. That way, it's defined. So it doesn't. We're not creating a definition. The definition already exists. And so as you continue on page 1 of the amendment, once again, this already exists into existing code. And then if you go to page 2 of the amendment, on line 33, on page of the amendment, on line 33, you see it defines criminal investigation. Once again, that's existing code. Because of inquiry from committee members, we're just gonna make sure we define that in this bill also. And then you'll see underneath that it just push down the existing definition that's in the bill, the department, investigation, legal custody, and parent. That is already defined in the bill. But because we put those 2 definitions up front, we just push everything down. Yes. With the amendment, if you look at page 3. Okay, starting on line 50, it says, replace line 91 on page 4. So let's go to page 91 on page 4. And what it does on line 91, in front of the word department, we added the word non-confidential. What this section does for the audience, this section talks about the right to review and copy at no cost all departmental documents. We're gonna put the word non-confidential in front of the word department documents. I want to emphasize that if it's non-confidential, right, parents or legal custodian can have access to that.
Let me add to this. Typically, you file like a subpoena, and once the subpoena is filed, then it goes to there's an objection made, and then they do an in-camera review of it, and then the judge releases that. Right now, what rights does a parent have to review the records in a file? Or do you have to have a court order still to review anything?
That's what you have to have.
Okay, so it'd have to be a pending court case in order to be able to issue a subpoena.
Yeah, there's just so much in those files, and everything's considered confidential.
Okay.
I mean, I could go into detail about the types of things that would be in those particular files. Well, I mean, you're talking about, I can tell you that my name may appear in a file, yours may appear in a file, as someone that you may not have provided any sort of information or testimony, but someone may have used your name in that particular file. There's just so much that's in there, and in the end, it's the protection of the rights of those kids. And so, yeah, if a judge orders it, you hit it right on the head, and of course I know you know. And the judge too can put a lot of restriction on that information as well, even in camera, because what we don't want to have happen is someone show up there and themselves, take pictures of documents and things like that. We've had it happen, and they show up on social media, where people's names show up and things show up. So we would object to any sort of information like that.
Is there any federal statute that deals with the confidentiality?
I'm sure there is. I'm not aware of it off the top of my head, but I can find that out for you. That won't be hard.
Okay. And part of that reason putting the word non-confidential, just once you get feedback from different stakeholders throughout the state, the child advocacy centers out there had concerns. So that was just to specify non-confidential, but I understand from this dialogue, everything is considered confidential in the records. So we might have to come back and look at that. Well, that's the purpose and intent, getting feedback from the stakeholders, trying to make the bill the best that we can. Next on the amendment, if you look at line 54, it states, replace lines 93 through, on page 3 of your amendment. Right. Okay, so on line 54 of the amendment, it states replace lines 93 through 94 on page 4 with the following. And so it's line 93. I'm trying to highlight what we changed there. And what we add in there is, any investigation where law enforcement has opened a criminal investigation. This is actually comes from the previous amendment. It stated that, any investigation where law enforcement has opened a criminal investigation into the parent or legal custodian for any crime where the victim is the child who is the subject of the department investigation. So just back it up to, this is still doing access to records at no cost, for non-confidential records. But also it says the department may withhold documents for the following: any investigation where law enforcement has opened a criminal investigation. And then it goes on to say that the second thing is the department may withhold any communications that would be considered privileged under the counsel-client privilege as established in Alabama Rule of Evidence 503A, including but not limited to communication between the child and a licensed professional counselor, counselors associated, or victims counselor at a child advocacy center. And then lastly, which is already in the bill, the department may redact documents to protect the confidentiality of reports and other sensitive communication. So the reason I added that in there about may withhold communication that would be considered privileged. The counselor, the child advocacy center, once again, just getting feedback from the stakeholders. And hopefully you see what I'm trying to do here is valid concerns out there. We want to continue to make the bill best that we can to address those concerns. So that's the effort there. And then going back to still on page 3 of the amendment, if you go down to line number 66, it states replace lines 108 through 110. So let's go through the bill 108 and 110. This was one of the previous amendments, was when we just put it all in one. This is to allow legal counsel to attend any communications, interviews, and so forth. If you go on the top of page 4 of your amendment, this is what we added to address concerns from last week. We'll start on line 75. It states, let me just read over here. Yes. I'm going to read it. This subparagraph, once again, saying allow the legal counsel. This subparagraph does not require the department to modify its investigation timeline or schedule communications, interviews, or meetings around the availability of the individual legal counsel. What we added was, if doing so would jeopardize the welfare and safety of the child who is the subject of the investigation. Several members last week had questions about, okay, got legal counsel, then we will make sure DHR has his timeline for the welfare of the child, not the parents of the counsel. We will make sure DHR stay within the timeline. But I think a couple of members just want to clarify that you still got to work with each other.
By an attorney that doesn't show up and all that, I think is a scenario we were discussing.
Right. So, but on line 75, we put, if doing so would jeopardize the welfare and safety of the child who is the subject. Once again, we want to make sure DHR still, their focus is the welfare of the child, which ours are too. But we just want to clarify that. So that's the purpose of this, is to clarify the conversation we had.
Is that saying, if the DHR is interviewing a child to determine if there was a situation that required a removal, that the parent's attorney would have access to that interview?
Well, if the parent is there, if the parent has opportunity to be there, the counsel, they represented by the counsel.
A lot of these, I would assume, they're having those discussions with the child without the parent. Is that correct?
Well, whatever they do have protocols where they would involve, in particular with the child advocacy center, for example. This is when the parent is present, they have to be at a meeting called by DHR. This is just saying,
so
we won't allow
if the parent is showing up, they have a right to counsel. That's
right.
What we're saying.
Yes.
Not that they have a right to have counsel at every interview that's done in the investigation. Does that make sense? Am I articulating that right? So, you know, if you have,
It's my understanding that the parents would not be present when the law enforcement is investigating the child. Is that correct?
That's,
how it's currently
yeah,
done?
so there are instances when we get calls from the school, from a hospital, from law enforcement, for example. I'll just use a general example. Law enfortement busts a meth house. There's kids, they're crawling around. All right, so now, but the parents are there, they're being arrested. So we now are gonna come out, we're gonna speak with the kids, we're gonna see the kids and make sure that they're safe and try to work with the family. Maybe not be the parents if they're both being arrested at the time, but with the family. We want that child to be in what I would call a comfort zone. So we're working a safety plan. I know you've heard those. So we're trying to work a situation whereby we can have that child remain with family as long as that child can be protected by that particular family member, so to speak. If that cannot happen for whatever reason, there's nobody available, then we're forced to pick up the child, place the child in foster care until 72-hour hearing. Now, as far as legal representation for those parents, they may be in the back of a police car or not. That happens occasionally, but there may just be a situation whereby.
To pick the child up, at that point, there has to be an open investigation and that actually, if you have a 72-hour hearing, you actually have a court case started in law enforcement. And then the individuals will be appointed counsel.
That'd be up to the court, yeah, to do all that. But right there in that particular instance, and that was a pretty extreme instance. We may have a situation though where we go to a school, this is one that's a little bit more common. We may go to a school whereby a child is complaining about being abused by, we can say, a stepfather or a boyfriend that's living in the home. So now we get that information, then we go out and see mother, and now our objective is to ensure the safety of that child. So we talk to the mother about, hey, look, you're gonna have to get him out of the house if you want the child to stay here. If you don't believe the child, and you're gonna allow him to stay there, then we're gonna have to work on, again, a different safety plan. Do you have a parent that, or somebody that can keep this child in a safe position until we get to a 72-hour hearing, if we need to even go there? You know, we'll try to work with those parents, and if we can stay out of court, we wanna stay out of court. We don't wanna be in court.
Right. And, but, Rick, just to answer your question, like, this is strictly, the child, it's like, the parent.
yeah, so if the parent has a right to be there, the amendment is saying they have a right to have a counsel there.
Right. And then it's just also to clarify that if involving the child, the counselor, they cannot use a maneuver to try to prolong prolong the meetings and so forth. You still want to work with DHR, but still it's saying the priority is DHR to establish timeline. They have to comply with that, you know. Okay, so continue on page 4 of the amendment, on line 79. It states replace line 118 on page 5. So on the bill, go
Is line 4 of the amendment, or page 4 or page 5?
Page 4 of the amendment.
What line on the amendment?
Okay, 79.
Okay, I'm looking. Okay, I see it.
Okay, so now it says replace line 118 on page 5 of the bill. Replace line 118 on page 5 of the bill. And so, as you see in the bill, line 118 is, well, let me just go a couple lines before that, just make sure we're all on the same page. The department must record any communications or inactions it has with the child who is the subject of an investigation under this act. When the parent or legal custodian is not present, and preserve the records. Key thing is preserve the record, not give the parents the records, to preserve that record. And so this is what the amendment does here. It inserts, just to clarify, the department shall establish a procedure to complete the recording required by this subsection in a manner that does not cause additional fear or stress to the child. And it goes on to say, this section does not authorize a parent or legal custodian to access records related to or recording of any confidential communication made between a child who is the subject of an investigation under this act, and any other third party, including but not limited to a children's advocacy center.
But at this point, there's your bill, is there an open, is there a pending court case at this point?
Okay, at this point, it could not be. But once again, this just, if there was concerns about the recordings, and well, we want to make sure that the parents cannot get that. That's confidential at the advocacy center. So we're going to put language in here just to make sure if you ever get to a point, we still want to make sure we preserve that, and it's confidential, and this do not allow the parents have access to that.
So I will say this, if they don't have a pending court case, they have to file a separate lawsuit and request these records. And most people don't do it, they request these records, then you go before the judge for an informal, in-camera review, and then the judge makes a decision at that point.
Now we could take this out, but the reason I put this in, because I just want to make sure that some of the advocacy centers make sure they felt comfortable. Listen, you know, the word recording, digital recording, the parent preserving the record, they're like, well, even if the child's been removed, the child is replaced back with the family in the home, you still don't want what we discussed at the child advocacy center. We never want the parents have access to that. So that's the purpose of this.
If you have a child that's been carried to a child advocacy center, they've done an investigation, they've done the recordings, are all those records now preserved as part of the file on that particular child?
I don't know if any that are not. I don't know any that are not.
Okay. And then they gotta have in-camera review before it can ever be released.
And at the Child Advocacy Center, and you're probably aware of this too, so yeah, we're there when that child's being interviewed. Law enforcement is there when that child's being interviewed to see that. So yeah, it's all being recorded.
Okay.
It's all being recorded.
And once again, if the committee would come back, feel we need to take this out, we can take it out. But the only reason I put this in there, I also make sure that once again, some of the stakeholders had concerns. Well, I agree with your concerns. Let's clarify that, you know, so we can leave it in, take it out, tweak it. I'm comfortable with that. Okay, still on page 4 of the amendment, starting on line 91, replace line 155 on page 6 of the bill. So turn to page 6 of the bill. Okay, on line, replace line 155 on page 6 with the following. Okay, just gonna go over a couple sentences to make sure we all tracking. A statement that any statement or admission made by the parent or legal custodian to the department or anyone acting on behalf of the department may be used against him or her. So as we go down to the next subsection, next part there, we want to add that he or she has the right to provide the department with information, explanation, or documentation that may be relevant to the investigation, including information about any circumstances that may have contributed to.
Let me ask this question. On page 5 of the original bill, line 6, it had the provision that he or she has a right to withhold consent to all of the following. Now, my understanding is, without getting a court order, my understanding that DHR had concerns about that because they didn't want to have to go get a court order on everything that they have to do.
Yeah, that's one of the biggest, I guess, sticking points of the whole bill does is in that particular instance, whereby, you know, if we're having to contact the parent who may again be the perpetrator before we go to the school to see the kid, and now, you know, the parent, they're the perpetrator, liable to say, no, you're not gonna see my kid. So now we have to get a court order. Meantime, that parent can go get that kid from the school, disappear, do harm to that child, further harm to that child. May be upset with that child for disclosing to begin with. So that's where we have big issue, big problem.
What line number you on?
It's on page 5, line 135. It has that. Is there anything in the amendments that you have that actually addresses those concerns about requiring DHR to get a court order before they do any of these items?
Well, no, but going back to what Stan just mentioned about school, we had, this bill do not prevent DHR to pursue those avenues, going to school, whatever. In fact, that's a good, this bill doesn't prevent that. I'm trying to see, I read this,
I
how.
think under 6A, it says that you have to have a court order before allowing the investigator from the department to enter the home or interview the child.
Okay, so with that, well, with that, we specify, we're talking about the home here, so interview his or her child at the home, unless, once again, they have credible evidence that maybe child may be in danger, that overrides this. But to clarify about the school or the avenue or DHR, I think we specify the home, that we're talking about the home rather in this entire series there.
Okay,
So I can clear that up.
I think that's one of y'all's concerns still.
So
It would be, but he's right. I mean, Kenneth, you're right. But what I'm seeing here, where it says or interview his or her child, not and, for example, right there. Right now, I mean, I was an investigator in a county, smaller, mid-sized county back in the 90s. I've shown up to homes before, and the parents would say, no, you're not coming in, you're not going to see my child. Well, our job is to ensure the protection of that child. Am I going to force my way in there? Absolutely not. I'm get in my car, I'm going to leave, we're going to go get a court order, go get a sheriff's deputy, come back with us, see the child. That happens today, right now, all day. But this, the way it's written right now, would prohibit us from interviewing that child or seeing that child anywhere. An instance would be a school, a hospital, or anywhere else that might call us. Police station. We still couldn't without getting the parents' permission to see the child without a court order. That's the way this currently reads.
Okay, we clean that language up.
Make it where it just deals with the home issue.
Right. And I have had some people on the other side of this topic that don't think you should be able to go to school, but in this situation, once again, I think that's an avenue. Once again, the department needed to maintain that avenue. So once again, appreciate that feedback.
Now on the next one it has the medical and psychological examination of the child who's subject to investigation unless there's a court order. How is that handled?
Well, see, this again I think our biggest hang up again is when the parent is the alleged perpetrator. If the parent is the alleged perpetrator and you're having to get permission for that child to go see a counselor or medical professional, well, the parent's not going to allow that. Yeah. And so again, we're back in court. So we will go back to court. We do it occasionally now. It does happen. We think this bill's going to make it where we're in court a whole lot more. We're going to get a whole other army of assistant attorney generals. We get 50,000 calls of abuse and neglect every single year. So, I mean, you can do the math on that. We're in court already thousands and thousands of times. This will just expedite that. I think that from the perspective of the department, though, we don't want to be in court, but we also need, from our perspective, to ensure that our employees are handling these situations with respect to those parents. I think that's the most important thing. It's easy for me to say, having been with the department 33 years, but someone who's been there 2 or 3 months, hasn't experienced the things that I have, may not handle the situation exactly the same. So we work every single day to ensure that these individuals are trained properly, like they should be, shadow other investigators who have the experience that they need. But with our turnover rate, sometimes that can be difficult. So
now the C on line 144, page 6, the release of his or her medical and mental health records unless there's a court order. I think that's the way it's done now anyway. So that's not an issue, is that correct?
Okay, go back to B. So it sounds like we need to clean up some language, emphasize when if the parent legal custodian is not the subject of the investigations. Okay.
And then D, a urine test, is there, do you have to have a core now on that?
Usually the judge orders it. It just does in that 72-hour hearing. If the allegation involves drugs, the judge is gonna order it.
So that, is there any issue with D that you can tell?
I mean, again, and you're aware that we're working with the DA's Association, the Sheriff's Association, Child Advocacy Centers on a substitute. Right now, we've been working on that. We got that completed. It's been sent to all those entities for review and comment, and I hope to have that to you by the time you leave here on Thursday. Which some of that may line up with what you're saying right now and what you all are talking about. Some of it may not. I'm not absolutely certain. So I don't want to really comment on that so much. I just don't know.
And number 7, about explanation of individual rights, any issue with that?
What page is it on?
It's on page 6, line 149.
So what are we talking about there exactly?
I think it's just a matter of giving, expressing to the parents what their rights are. Whether it's you give them a statement or something to that effect, you may not have to do it in writing. You may not have to do it orally, but you might be able to just have it in writing.
To hand to them or something like that?
Yeah.
Again, I'd have to talk to our attorneys about that. I mean, all that stuff's on our website now. We should be handing them a card with all of our information on it.
Just a second. Okay. Yes, ma'am.
Current policy, and I know this because one of my friends is actually a worker, when they introduce themselves to a parent, they're supposed to give them a pamphlet that says this is what your parents' rights are. A lot of the workers just don't know they're supposed to, but that's what they've been actively doing in Baldwin County, Connecticut County, and several other counties. Because they have a little packet that it's like a little flyer, little trifold, that they give a parent when they meet them, and they give them a business card.
Is that a policy?
I'm not aware of that policy about handing out a pamphlet. We should be expressing to them, to the parents when we show up. Again, here's our contact information. All of the information you need would be available on this particular website. I'm not aware of any policy in regard to that.
All right, I know I'll hit a couple more things here, but we're still on page 5 of the amendment. Okay, on line 108. Go back to the page. Replace line 164 and 165. Back to 164, 165. Okay, this is listing the written notice required by subsection 3 shall include the following description of the report of the abuse or neglect, the full name and date of the birth, or the full name and the date of birth of the child who is the subject of the investigation, the name of the individual alleged to have committed the abuse, and then we add in a clear indication of whether the investigation is primarily a child welfare investigation or whether it involves allegation that may constitute criminal conduct. So let's go back to the definitions we put in it before. Several committee members had questions, so we're gonna add that just to clarify that. And then it also states, notwithstanding subsection B, to preserve the safety of the child who is the subject of the investigation, the department may delay providing the description of the reported abuse or neglect referred in subsection B1 until after the initial contact with the individual, provided that the description is furnished within 72 hours of the initial contact. So once again, there will maybe situations for the safety of the child that you do want to delay that. So once again, the feedback from some of the stakeholders, just trying to clarify some language that there may be a situation where and maybe you're on call by the department to delay that. But still, you stay within your guidelines of 72 hours of initial contact, you know. And then it goes on to further say the department shall establish a training, and that's just pushing the lines down, because since we inserted that, everything is pushed down in the bill. And then still on page 5, line 117, replace line 257 on page 10. So on your bill, go to page 257. And we're going to insert the entire section. This is from the previous amendment. We talked about instances where law enforcement is not the initial reporter. If the department receives a report based on credible evidence, which creates reasonable suspicion of child abuse or other criminal conduct, the department shall notify the law enforcement. Once again, it's just to codify the existing MOUs out there that's established in Erie County. And once again, it's just trying to address some concerns from law enforcement. So, wait a minute, if there's sexual abuse or criminal investigation, we don't want parents to be notified and interfere with our investigation. We would agree that 100%. So this is an existing administrative agreement between Erie County and the state with an MOU, just to codify that.
Is that how it's handled now?
An existing MOU with who?
With the law enforcement, with the sheriff, for example, it's, if you get a call, an allegation dealing with sexual abuse or any criminal acts, the MOU said you would contact the law enforcement, and so this just codify that. Just make once again, just make sure it's uniformity throughout.
2614.3. Right now, the law already states that right now a mandatory reporter has an option to report to either DHR or law enforcement. It is then incumbent upon the entity that the report was made to notify the other. Okay. So that's already in law. Okay. It's already there. And in our substitute, that'll be in there. Okay. So we'll make sure that that is, I can read it.
Let me ask this, that's the last one.
Well, yes, it is. Could you give me that code again?
Yeah, 2614.3.
Okay. Yep. Okay, all right. And if that's the case, we can take that out, you know.
You've got a lot of changes in yours, and can you make that into a substitute?
Okay.
Y'all gonna have a substitute?
I'm gonna have that for you by the time you leave here Thursday, and I think a lot of it's probably gonna line up. There are a few things that I think we're still at odds on a little bit, but I think some of it's gonna line up. Now, we're still waiting to hear back from the sheriffs, and we're waiting to hear back from the DAs and the CACs. Once we get that, then we'll have that substitute together.
And then we can make it a little easier to understand.
Look at both of them and kind of.
Okay. And I'll get mine dropped hopefully by the end of the day in the sub, and that way we can get everybody to have access to that. And there was a couple of tweaks, just clarify about the home, we'll make sure we get that language in there also.
Does any members of the committee have any questions? I think for today, if we can get those into a substitute form both, and so we can review, I think then we can schedule another meeting to address some of the concerns.
Okay, all right. And Mr. Chairman, if you don't mind, if anyone in the audience, stakeholders, based on what you hope you see that once again I'm continue, then I want feedback, and so if you have any additional issue concerns, let me know. So that's why we're here. I think we all in this room want to make sure that we have parents. Our first foremost is the best protectors of the kids. But at the same time, we know there's some that's not, and there's other people that abuse the kids. So we need a department. I can't say that enough, that we on the same team. That when you talk about DHR, you have a cheerleader here saying we need you, and anything we can do to help clarify, clean up some language, let me know.
With that said, please adjourn.
Sorry about that. I had to keep a copy in case Representative Drummond or Ross came.
Well, I'll get back with you.
No,